Today we are looking at the part 7 on the commonly asked questions pertaining to human resource management. So a lot of people tend to ask different questions pertaining to the human resource management processes that tend to happen within their organizations. So it is always important for us to appreciate what kind of responses we can be able to provide to such kind of employees or employers, and also maybe other stakeholders. So what is important for us to appreciate that these sessions are organized for us to get a gist of the whole thing, to say how things have to be done. So today we'll be looking at some questions pertaining to the Employment Act, but also some other human resource management processes. So the first thing we need to ask ourselves is to say, what should happen whenever any employee has died? Is an employer obliged to provide coffin, funeral expenses, or what does the law say? So what we need to appreciate is that in Malawi, the law is silent on what the employer can provide in case of death of an employee. Yeah, so it doesn't provide anything to say what should the employer do, but we know different employers provide different things to deceased employees or their relations, maybe coffins, transport for burial. I think this is why, in the absence of the law, this is what makes it difficult for some employers who are coming from outside the country to understand why should the employer be able to pay for coffin and also some other funeral expenses. Also, at the same time, we should also be mindful of the fact to say these people, foreign employers who have come to Malawi to invest, they're also coming from a background where maybe they don't use coffins, maybe, for example, or maybe they don't believe in maybe being transported to one's home village, but also at the same time, they don't also, they have got some kind of insurance companies which maybe manages all the funeral arrangements and all that. So you might find that in the context of Malawi, it's only a few people who are on insurance funeral or funeral insurance policies, for example. So it becomes a very, very problematic for them now to appreciate why they should be able to pay for the funeral expenses. So we should be able to understand and also maybe explain to them maybe how things are done here in Malawi, and also at the same time organizations might need to have the terms and conditions of service which is going to guide on how they should be able to support their employees whenever they have died, or even relations of employees. Which relations can they support? Is it the wife? Is it the spouse, or maybe children, or maybe parents? What kind of support can the employer provide? It all depends on, as I said, it's not by law, so it all depends on what you have put in your terms and conditions of service, or maybe your funeral policies as an organization. But at the end of the day, I think the experience has been when you don't provide issues like coffin and transport, for example, especially to the employee, it becomes a big deal of a problem for most people. Not they fail to understand why you are not doing, because they are used to say employer tend to provide support to the deceased employees. And also some people would ask to say, when one has been suspended, maybe before a disciplinary hearing, should he be on suspension with pay or without pay? What about when when it's a suspension as a punishment for a misconduct? This is after a disciplinary hearing. Yeah, we should know that suspension can be done in two forms. One, before the hearing. This is whereby now you want to, before a disciplinary hearing, you want to investigate the issues and all that, and also should be able to find out more about the issues at hand. And at the end of the day, on this kind of suspension, regardless of the offense, should be with pay, and also the period of this kind of suspension, people would ask to say maybe for how long even can one be on this kind of suspension. So what I tend to say is when you are paying for this kind of suspension, it means you'll be able to fast track the process because you are losing money. So, but if you do it without pay, which is anyway illegal, you cannot suspend someone without pay, which is illegal, for example. So when you have done that, you might find that you're able to do it within the short period of time if we are doing it with pay. But if you do it without pay, it means it's illegal. And so the law doesn't provide how long you can one be on suspension without pay. So I mean with pay or without pay. Of course, without pay, as I said before a hearing, it's not allowed. But with pay, you can do before the hearing. So we can also suspend an employee after a hearing as a punishment to that particular employee, to say maybe we have seen that maybe the only punishment that we have been able to give you is this kind of suspension. So such kind of a suspension should be can be with pay or without pay as a punishment. So that's what we need to appreciate, that you can be able to suspend someone after the disciplinary hearing with pay or without pay. And on the maximum period of suspension, I've said there is no limit to say how long can you be able to put an employee on suspension. And also sometimes it also happens that an employee might be victimized by the employer, might have some grievances. So we are the people tend to ask to say, if someone has got a grievance with his employer, can he be able to sue the employer? Yeah. So this is an important question. You can be able to say, because if the employer is not happy with the employee, then he will be able to discipline that particular employee. But if the employee is not happy with the employee is not happy with the employer, then you might find that maybe he's resigning or maybe he's going slow. But at the end of the day, what we need to appreciate is, if an employee has got some complaints, some grievances, then he can take up to the employer. But he can only seek legal litigation as the last process. But what is supposed to happen is to make sure that the issues have been complained within the organization, the supervisor, maybe to management, maybe to the CEO, maybe to the board. When he is not satisfied with the internal mechanisms or how the issue has been resolved, then he can be able to complain outside the organization. So can go to court or the labor office to complain the issue. So if you ask me to say, is the employee obliged to sue an employer? Yes, he's obliged to sue whilst in the course of employment. Of course, it happens that maybe we have seen, I think there's an issue at the SCB where an employee had complained to his employers, but maybe they're not supporting him, so the employee had to complain at the office of the ombudsman. So like as I said, in government you can complain to the ombudsman, but also at the same time whilst in the job. But it becomes a big problem when now you look at these issues from a private sector perspective, to say in a private firm, for example, if you have sued the employer, maybe the employer will not be happy with you, maybe he can fire you, and also other things. So these are some of the, just to maintain the good relationship. That's why maybe most employees will not be able to sue, especially in the private sector. But maybe in the NGO and the public sector, because there is nothing like this is the owner of this particular organization. Yeah. But at the end of the day, what is important for us to appreciate that we should be able to take this process with caution, to say, do you really have a case valid enough for you to sue, for example? But also there are certain moments whereby people would say, for example, if one is on sick leave, for example, and has exhausted the entitlement of the sick leave, for how long can one be continue being on sick leave? So what we're trying to say is, the law provides the minimum to say you're supposed to be on 2 months full pay and 1 month of on half pay. So when you have covered that, these 3 months which you are supposed to be on full pay, and also another month you have to be on half pay, when these have been exhausted, then the employee can express interest to retire on medical grounds. But it becomes a bit of a difficult for the employer just to terminate services of this particular employee on medical grounds. So it's always important to say, to engage the employee, to say, you look here, we have a situation whereby where you were on full-time pay, and also there was a time we were on half pay. Now you have exhausted these days, this month. So what's your plan, for example? Yeah. So you can always agree. Of course, some employers, especially in the public sector, it becomes a challenge for one to be on such kind of a sick leave without pay, for example. Yeah. So maybe someone can be sick for 1 year, still continue getting his salary or her salary. But in the private sector, in your sector, it's always a problem that you cannot be able to keep an employee while sick for that long. Yeah, so that's when issues of termination on medical grounds, or maybe retirement on medical grounds, tend to come in. So you can be able to initiate that and be able to do that. So maybe other people would ask you to say, who should initiate the retirement on medical grounds? As I said earlier on, the employer would initiate by engaging the employee. Yeah, of course, the employee can also express interest to retire on medical grounds, but most employees will say what will happen. So the employer can take an initiative to engage the employee. So people would also argue to say, if someone has retired on medical grounds, for example, is he allowed to rejoin the organization maybe in future? Yes. If the opportunities are available, if he's back to fitness, this is a skilled employee, and you are like, no, we're going to be able to re-engage you and also join the organization. So it's always allowed. It all depends on availability of positions, but also if the organization is comfortable to bring this particular employee back into the fold. But it's all up to the employer to decide. And also people to say, sometimes can an employee go on maternity leave maybe just after a month she has joined, just after 2 months she has joined, maybe within a year after joining the organization, can she be able to go on maternity leave? I think the law is not specific to say for after serving for how long can an employee go on maternity leave, but the law says every 3 years one has to go for maternity leave once. Likewise, the paternity leave. But you can go on paternity leave within a month. You can go on maternity leave within a month. So you can even join an organization and say start working whilst on maternity leave, or maybe you can proceed on maternity just after joining the organization. It all depends on what you have agreed with the employer, and also to discuss all those issues, maybe how we are going to manage the whole thing. But maybe some works can be done whilst home and all that. But what is important for us to appreciate is that you cannot bar someone to go on maternity leave. That's what also is very, very important for us to appreciate, because you are looking at that's why it's not even important for you to ignore someone to go to apply to recruit someone, overlook someone for recruitment just because she's heavily pregnant, because some of these things you might lose the best employees for your organization. You're like, because this pregnancy is temporary thing, but maybe you're looking at the longer period that the employee can be able to save your organization. So these are some of the things that also we should be able to appreciate. And also people tend to ask, what are the minimum wages in Malawi? So every year the Malawi government tend to issue out gazette on the minimum wages in Malawi. So it's also important to follow the minimum wages that are there in the country. So there are different categories. I think the recent one, which is about to be gazetted, is looking at to say there is a minimum wage for domestic workers, which is they're saying it's around 52,000 kwacha. There's also a minimum wage which has moved from 35, about 35. They have moved from 35 to 52. There's also a minimum wage for these other ordinary employees, which has moved from 50 to 90. But also they have categorized minimum wages for micro, small and medium enterprises, and also they have also provided for minimum wages for different categories of truck drivers, like those driving 30 tons and going international, and also maybe 30 tons doing local, and also others who are driving less than 30 tons. So all these minimum wages are always provided by the government. So you should always be on the lookout for such kind of gazettes to say what are they talking about when it comes to the minimum wage. And there are also some cases whereby a contract would be changed from unspecified to a specified for different reasons. Maybe a company is not going fine, or maybe there's a change of a donor and all that, and has got brought in. So people tend to ask to say, if you have changed a contract from unspecified period to a specified period, are you supposed to pay for severance pay? So it all depends on what you have agreed. Are you retrenching such kind of employees? Are they continuing within the organization? So because we say the severance pay is only payable when there is a retrenchment and not under any other circumstance, or if it's determined by the court. So severance can only be paid when where there is retrenchment, redundancy, and also when it has been determined by the court. But on all other situations, retrenchment cannot be applicable. So it's up to the employee to prove that this kind of change from unspecified contract to specified contract, for example, has led to retrenchment or is retrenchment. But in short, what I can say is where there is no change, because there are certain things which you also be able to appreciate, to say where there are changes in the company in terms of the policies, the terms and conditions of service. I don't think there's any kind of for someone to worry. We still have to continue working within the organization. But also there are also moments whereby an employee would adopt a child, for example. She's entitled to maternity leave. A female employee has adopted a child, a young child. Is she entitled, a newborn, for example, is she entitled to maternity leave? Someone maybe her sister has just passed on, so she has to take care of this particular kid. Maybe her sister has passed on after delivery, for example. So there's a young child. So can this person be allowed to go for maternity leave? So it all depends on discretion of the company. For adoption, for a legal adopted child, there's nothing you can do, but that's her child, so she should be able to go on maternity leave. For this one who is just taking care of a child, not wholly adopted, but just because it is a child of her sister who has passed on, then it all depends on the cautiousness of the organization to support this particular employee. So can be allowed to go on leave and take care of this particular child. So this all depends on the policy of the organization, or maybe you might need to have also a new terms and conditions of service, such kind of situations, and specify to say we are looking for this kind of a clause which is trying to elaborate on what can happen if maybe a sister of an employee has died and this particular sister has to take care of this particular child. So I think we also don't know that as I said earlier on severance pay, people will say under what circumstances severance pay payable. So as I said, severance pay after the amendment of 2010 Employment Act, due to the coming in of the Pension Act, the severance is only payable where there is retrenchment or redundancy, or even when there is a determination by the court. So these are some of the things which should also be very, very important for us to appreciate. And also other people tend to ask to say, for example, as an offender within the organization, you want to appear before a disciplinary hearing, can you be able to go and seek legal representation during a disciplinary hearing, like coming to the disciplinary hearing with your legal counsel, for example? So what I got to say is to say the legal counsel is not supposed to attend a disciplinary hearing or maybe represent someone at a disciplinary hearing, because this is an internal process which doesn't require to have lawyers. But if the employee wishes, can have his or her witnesses or the members of the union to watch whatever is happening during the hearing. These are some of the things which are very, very important for us to appreciate. So for today, we're trying to discuss these issues, and I hope you have enjoyed the video. Subscribe to my YouTube channel, and also maybe tell others to subscribe to this YouTube channel. You want some services from our organization, especially on the terms and conditions, because most of the issues which we are discussing have to be in the terms and conditions service or in the different policies. Then you should be able to engage us as Change Consult Group. We'll be able to come to you and support you in one way or another. At CCG, our email is at ccg@changeconsult.org. Our email is ccg@changeconsult.org. So you can be able to reach out to us and we'll be able to support you accordingly. Thank you so much and have a blessed time. Thank you.